aim, you can observe that the following is based. Labor is not a product or a commodity. So labor is a human being with blood and flesh. So he should be treated with dignity and with equality. And there is freedom of expression. And poverty anywhere constitutes a danger for the prosperity of any country. It need not be a specific underdeveloped or developing, but for any country, poverty would be a danger for the prosperity. And the war against want requires to be carried on by unrelenting vigor with each nation, and there should be continuous and concentrated international effort wherein the representatives of both the workers and the employers and as well as the government should work equally to have the status of equity and equality. Now, coming to the objectives, we have the objectives based on the Declaration of Philadelphia to set and promote standards and fundamental principles that will actually have rights at work, create greater opportunities for women and men, and in a way that should be giving a decent employment and decent income for their livelihood, enhance the coverage and effectiveness of social protection, and you also have the strengthening of tripartism and social dialogue. So who are the triparties? Yesterday also I told it is the workers or employees and employers and the government. So these are the three parties generally which are there in the labor welfare whenever we are talking about. So the tripartism, so all the three parties, whether employees or workers or the employers and the government, should have a social dialogue and resolve the issues amicably. And formulation of international policies, creation of international labor standards, and also the training and education and research activities that will really help in advancing all these efforts, adequate protection for the life, health of workers, and as well as the provision for the child welfare and maternity protection. So these are the set of objectives what the ILO has based on the Philadelphia Declaration. And then we have the International Labor Code. So the body of conventions and recommendations adopted by the International Labor Conference, they constitute the International Labor Code. And this has been adopted by many conventions and recommendations based on the changing labor environment. And now the code has become the for labor lawyers throughout the world what court juris is. And moreover, the International Labor Code covers and a range of important subjects in the labor and social fields, which are, it can be the human rights, labor administration and industrial relations, it can be the conditions of the employment, the policy of the employment, employment of the children, young persons and women, industrial safety, health and welfare, social security, then we have the indigenous tribal populations and migrants and plantations workers. So what are the things you have to do with all these, the different set of bodies where you're going to consider for the ILO? Now, the three organs of the ILO are International Labour Conference. This is the General Assembly of the ILO. And the members meet in June month every year to discuss the affairs. And you have the second organ, governing body, the Executive Council of the ILO. This body meets in March, June, and November. Thrice in a year they meet. And we have the International Labour Office, a permanent secretariat, which works throughout the year. So these are the three organs of International Labour Organization. Now, the International Labour Conference, it has been continued with its first session since 1919, and they meet once in a year. And the body, the governing body, adopts whatever the program and the budgets which have been discussed. And the international labor standards in the form of conventions and recommendations provide forums for the discussion on social and economic and labor related issues. And the governing body of the ILO is the executive wing of the organization. So it is also a tri-party. So since 1922, India has been holding a non-elective seat on the governing body as one of the 10 countries of chief industrial importance. And these people, they try to discuss the various committees relating to the governing body. It can be program planning and administration, freedom association, legal issues or international labor standards, or it can be employment and social policies, or it can be the technical cooperation, sectoral and technical meetings related issues, so on and so forth. And the International Labour Office, it is active, and the day-to-day implementations of the decisions taken by the conference are discussed here. And it is a day-to-day activity. And the relationship between India and ILO, if we see, India's participation in the International Labour Organization has witnessed a kaleidoscopic journey. And since the inception, that is since 1919, the ILO has recognized India as a founder state, and uh, we as a member, we as a board have been taking decisions which are to bring peace and harmony in the labor workforce. And coming to the ratification of ILO standards by India, the ILO confection and recommendations have been greatly honored by the working class all over the world. So these ILO standards are considered the embodiment of social justice, and by the underprivileged. Uh, Wherein, whenever we are talking about the labor, they are underprivileged because they don't have any decision making power, they don't have any say, and they are the people who are always. The employers always try to uh, exploit them by using excess work with the minimum payment. So, in the ratification of ILO standards by India, there's a detailed procedure which has been undertaken for ratification of the conventions and the recommendations. And in India, the treaty has treaty making power is regarded as the executive act, and this is within the contemporary of the government of India. And here, according to the scope of implementing the legislations in India, it is not limited within the legislative jurisdiction of a union parliament. It also needs to consider the nation's fundamental rights before making the treaty. So, in other words, there is no constitutional limitations upon the powers of the union government. So, to enter into the treaties or any other states or international organizations. So, the United States and the United Kingdom entered into a treaty in 1916 for the protection of migratory bird, which in their annual migrations, certain parts of the United States and Canada. And the Director General of the International Labour Office is obliged by Article 19, subsection 4 of the ILO Constitution to send a certified copy of the convention or the recommendation to each of the member. Now, coming to the conventions and the recommendations of ILO regarding the basic human rights, the following are the conventions: freedom of association and protection of the right to organize, forced labor, and equality of opportunity and treatment. So here, the freedom of association and protection of the right to organize will reserve the privileges to set up the joint organizations based on their personal preference. So without past authorization, the workers and the employers will reserve the privilege to set up and join the organizations. And the Trade Unions Act 1926, it restricts the number of outsiders in the executive of the trade union. And there is no restriction on outsiders in the Federation of the Government Servants. And also, the government in the public interest can forego any association or trade union and detain or arrest any trade union leader under the Essential Services Act 1967, Prevention and Detention Act 1950, and the Maintenance of Internal Security Act 1971. And right to organize and collective bargaining. So in Convention number 98 in the year 1949, it says that the workers to join or not to join the union with full freedom without any fear. Okay, it calls upon the member that states to create condition and institutions for promoting the right to organize, negotiate between the employers and workers, And the regulation terms of the employment, conditions of employment using collective agreement, all these come under the bargaining conditions. And the last one being the abolition of forced labor. So Article 23 of the Indian Constitution prohibits forced labor or involuntary labor, and so indirect constitutional compliance of the above conviction. So here, I mean, you cannot force any worker or any labor into forced labor, and the they have freedom of thought, they have freedom of expression. So they have every right to say no whenever there is, I mean, whenever they are forced to do any particular work. Okay. And then we have the convention and recommendations concerning equity of opportunity and treatment. So equality is nothing but equality of employment opportunities, treatment, and in the same manner where there is no discrimination in the treatment or in the work delegation based on sex, race, religion, or place of birth. Okay, so there's no such discrimination, and equal remuneration for both men and women for equal work. This is also another important aspect. And the influence of ILO standards on Indian labor legislation, if we see the Constitution of Republic of India, has been framed to fulfill the promises made to labor during the independence struggle in which they have participated wholeheartedly. And the directive principles was placed in Part 4 of the Constitution concerning the labor welfare. And if we see, the state was, however, under the obligation, subject to its economic power, to realize the goals set in Part 4 of the Constitution of the India. So there are several obligations which have been imposed upon the employer, and the non-compliance of which entails to penalty or prosecution, or it can be both penalty and prosecution. And on the other side, the provisions have also been made to curb the unfair labor practices such as strikes, okay, go slow, or it may be the opportunity where you want to resolve an industrial dispute with the weapon of strikes or lockouts. So no, that is where the labor or the employer should amicably solve the industrial disputes. Either it can be through collective bargaining, or either through arbitration, or either it can be the mediation. So any of the process has to be adopted to solve the disputes. And India has ratified 47 out of 185 conventions adopted by the International Labour Organization. So the ratification of the convention has put under the organization of implementing the provisions through the incorporation of the labor laws. And role of ILO on labor management relations, if we see, ILO plays a very important role, a very significant role in the management relations throughout the world. And it has passed so many conventions and recommendations, and wherein the every country need to follow the conventions and recommendations based on the adaptability. They might follow a few conventions and few recommendations. And it has been uh, a natural trend at the national level towards a greater focus was on human rights. So under the influence of such factors, we give more importance to the human rights, and there's no other great influence which have made the question of human rights a tropical issue throughout the world. And well, what is the critical and main functions of the ILO? The ILO has the following goals, like to establish international labor standards and to collect and distribute information on labor and industry conditions and to provide technical assistance. So these are the three main goals which have been cited by ILO. And concerning India, it has ratified 6 out of 8 core fundamental ILO conventions, and they are Forced Labor Convention in the year 1930, Abolition of Forced Labor Convention 1957, Equal Remuneration Convention 1951, and the Discrimination, that is either it is the employment and occupation, and the Minimum Age Convention, which is in 1973, and the Worst Forms of Child Labor Convention in the year 1990. India has not ratified the core fundamental conventions, namely freedom of association and protection of the rights to organize conventions and right to organize and collective bargaining convention in the year 1949. So these are the ILO conventions ratified by India. If you can see, the hours of work, unemployment convention, night work, minimum age, okay, weekly rest, medical examination, equality of treatment and inspection, forced labor, labor inspection convention, final article. Okay, so all these are the conventions which are ratified by ILO. And the difficulties in the adoption of conventions and recommendations of ILO, as mentioned, the conventions and recommendations of ILO seek to prescribe and these indicate internationally uniform minimum labor standards. So it is to see, and each country has a different set of standards, I mean, different set of mindsets, and it is very difficult to form a uniform code. And if you see, the uneven economic development of the world scale presents the main hindrance in the adoption of the convention and recommendations. As I said, each country has a different landscape and different set of growth policies and development policies. So to bring about all on one platform is difficult. So that is where it cannot be adopted by all the countries. I mean, each country has their own set of obligations and what do I say, limitations. And coming to the next subpart, we have completed the first block with 3 units. The next block has the legislations of the factories, recruitment and training. Under that, we have the Factories Act 1948. Now, what does the Factories Act say? The Factories Act was the first Factories Act which was passed in the year 1881, and it is a comprehensive version which was introduced in 1911, and it was later amended 4 times based on the recommendation of Reggae Committee. The Government of India enacted the Factories Act of 1948, and if you see the important provisions and the objectives, the main objective of the act is to ensure to the workers employed in the factories health, safety, welfare, proper working hours, leave, and other benefits. And the act also requires that the workers should work in healthy and sanitary conditions for that purpose. And the act is also applicable to all the factories defined under section 2M of the act. Now, coming to the definition, section 2 of the Factories Act 1948 has given few definitions. Now, what is a factory? It means it is a premises which is a part of the manufacturing process, and it is carried out with or without the aid of the power with at least 10 or 20 persons. If it is with power, 10 persons. If it is without power, 20 persons should have been employed on any day of the preceding 12 months. So preceding 12 months in the sense an year. So in an year, as a year consists of 12 months. So in a year, the employment should have been done and the work should have been carried out. And occupier of a factory means the person who has ultimate control over the affairs of the factory. It can be a partner in case of and it can be a director in case of a company, or it may be the chief. I mean, it can be the a person who is actually appointed by the company to run the factory, and it can be any person. I mean, it can be a partner, as I said, in the case of partnership firm, a director in case of a company. And in case of the company, they might appoint any person who is going to be the in charge and who is going to take care of the affairs. So here, the name of the occupier of the factory is required to be informed to the chief inspector of the factories. And who is a worker? A worker is a person who is employed directly or through by any agency. So it can be with or without the knowledge of the principal. And he is working in the concern. Any job or task completed or going to be completed is by the worker. Okay, and whether for remuneration or not, in any manufacturing process, in any other kind of work, incidental or connected. So it can be incidental, connected with the main manufacturing. And what do you mean by employed? So the concept of employment involves three main factors, that is employer, employee, and contract of employment. The employer is the one who engages the service of the person, and the employee is the one who works for the firm or another person on hire. And the employment is the service between the employer and employee, where they try to agree to the terms and conditions for the employment process. So it will mention the various conditions which are to be prevalent when the employment process is going on. Okay, and what is hazardous process? Hazardous process means any process or activity in relation to an industry, uh, unless special care is taken, raw materials used or intermediate or finished products, byproducts, waste, or anything else. Okay, so all these are specified in schedule first schedule, and these are the, I mean, if it is relating to the cause of material impairment to the health of the persons, and if it results in the pollution, it is considered as hazardous process. And what is manufacturing process? The process of converting raw material into finished good is a manufacturing process. So other than that, altering, repairing, or finishing, packing, oiling, washing, cleaning, breaking, all these come under manufacturing process. And it can be generating, transmitting, constructing, reconstructing, or it can be preserving or storing any article in cold storage. So all these come under the manufacturing process. Now, what are the essential elements of a factory? So first of all, when I'm saying a factory, it should have a premises, and they must be manufacturing process. So what is manufacturing process? Any process wherein you try to convert the finished into semi-finished process or finished final product. And there must be at least 10 workers if it is with power, or 20 workers if it is without power. And the manufacturing process is carried on for the last 12 months. Okay, for the preceding 12 months. And you also have the following, which are not covered under the definition of a factory, that is railway running sheds, mines, mobile units of armed forces, hotel and eating places or restaurants. So these four are excluded from the definition of a factory. Now, factory inspectorate. So factory inspectorate is necessarily that the approval from the chief inspector of the factories is obtained for the plants in the factory. So the occupier has to arrange to register the factory with the chief inspector of the factories and obtain necessary license. So without license, you cannot run the factory. Now, the approval and licensing and registration of the factories. So you need to have the submission of plans of any class. Okay, so the government has made it compulsory in licensing and the registration of factories, the following matters. That is submission of plans, obtaining previous permissions of the state government, and considering the application for permission for the submission, nature of plans and specifications, and the authority certifying them, registration and licensing factories. And for that, the fee payable is there. License may not be granted or renewed unless the notice specified under Section 7 is given. Now, what is this automatic approval? If an application is made for the approval of the site for construction or extension of the factory, and it requires the plan specifications have been submitted by the registered post to the state government or the chief inspector. And if there is no reply received from them within 3 months from the date on which it is sent, the application stands automatically approved. So, I mean, if you send the application for the approval for the construction or extension of a factory, and within 3 months you don't get any reply, it means that it has been automatically approved. The next is appeal against refusal to grant permission. The central government against the order of the state, or the state government against the order of any other authority, may have refused, and so within 30 days they can appeal to the central government or to the state government. And coming to the provisions relating to the health, safety, welfare of the workers, or working hours of hours else under the work. So what are the provisions? It can be cleanliness. The section basically specifies the issues of cleanliness at the workplace. So, I mean, you cannot have dirt and, I mean, clumsiness whenever there's a workplace. It should be kept clean. And if any dirt or the garbage is there, so that has to be removed. And disposal of waste and effluents should be taken care properly. The whatever waste has been accumulated, there should be a process of getting rid of that, disposal of that. Ventilation and the temperature should be maintained proper. Dust and fume exhaustion should be there. And then artificial humidification, where in factories where it is required, artificial humidification that should be uh, accordingly incorporated as per the state government's orders. And overcrowding in a room, you cannot overcrowd the people for the work. I mean, enough space should be given to the employees for working, and there should be proper lighting, clean drinking water should be available, and the restrooms and the toilets should be cleaned and maintained properly, and even the spittoons should be maintained properly in the factory, maintaining the hygiene. And the provisions relating to the safety, you can be the fencing of the machinery. So for every dangerous machine, or for a machinery in general, where the cautiousness should be followed, there should be proper fencing. And when a machine is in motion, I mean, and the work near the machinery which is in motion should be taken proper care. See that there is no intersection between these two. And employment on dangerous machines, wherein whenever the employment is being given, so the new people or the young people should not be given the opportunity, only the experienced people should be given the opportunity. And the device for cutting off past. So this provision will be striking gear and devices for cutting power, or in any other emergency case. So they should have special devices for cutting off of power. And self-acting machinery. So no factory should allow any part of a self-acting machine in any factory to run within a distance of 45 centimeters. And the casing of the new machinery is mandate, and prohibition of employment of women and children near cotton openers is also to be taken care. And the lifting machines or the hoist machines on the lifts. So whenever they are there, I mean, you need to be very careful. At least a competent person should be there with who has the minimum knowledge of I mean, how to deal with, because these are the things which are dangerous in a factory premise. So people who have been appointed need to have proper knowledge. And you can have the pressure plant, or floors and stairs, or pits and sums, which are opening on the floors. Okay, so excessive weight, protection of eyes with the protective tools like helmets or glasses should be given. And precaution against dangerous fumes and smoke. And whenever you're using the portable electric lights, so any precautions regarding that, explosions and inflammables, and precaution in case of fire. So, and any specific detective parts, or which are, I mean, when the inspector feels that the conditions in the factory are dangerous for the human life, I mean, you need to have a certain set of precautionary things which are to be taken care by the factory. And the safety of buildings or machinery. And you have the maintenance of the building. Safety officer should be there. The power to make rules. So the state government has the power to make rules which under this section, wherein it has to take all the precautionary measures by the inspector whenever it comes to the safety of the employees who are working in the organizations. And when it comes to the provisions relating to the welfare, we have the washing facilities. In every factory, there should be adequate and suitable facilities for male and female for washing, and facilities for storing and drying clothing, facilities for sitting, and it can be wherein you can rest for some time. So a good place should be given. First aid toolkit and the appliances, the canteens which provides clean food, and the food which is prepared with hygienic conditions, okay. And you the charges, whatever the charges they are collecting, should be of subsidized rates. And the shelter and the restrooms and the lunchrooms, wherein more than 150 workers are there in a factory, it is compulsory to provide shelters, restrooms, and separate lunchrooms. Creches, wherein more than 30 women workers are employed, you need to have creches. These are the daycare centers or childcare centers. And in every factory wherein 500 or more workers are ordinarily employed, you need to have welfare officers. And coming to the provisions relating to the working hours of adults, the weekly working hours, and adults should be allowed to work only for 48 hours in any week. And the weekly holiday says that there shall be holiday for one full day in every week, and such holiday should be on the first day of the week, and this can be substituted by any of the 3 days immediately before or after the first day of the week, provided the manager of the factory has delivered a notice at the office of the inspector and displayed a notice in the factory to this effect. So it need not be only Sunday, it can be any day. The weekly off can be any day, but subject to the display and the notice, the weekly off can be taken. And compensatory holidays. What are these compensatory holidays? When a worker is deprived of any weekly holiday, so in such case, the compensatory holiday can be provided. So the compensatory holidays of equal number of the holidays lost should be maintained, and it can be either in the same month or in the following month or within the next 2 months immediately should be compensated. And the daily hours of the work, it can be that is, the worker will not be allowed, a female will not be allowed to work for more than 9 hours in any day. And it can be adjusted to 48 hours for the week. So 9 hours is the maximum period, and within 48 hours, the weekly hour schedule, this 9 hours per day schedule can be adjusted. And intervals for the rest, no adult worker shall work continuously for more than 5 hours unless a rest interval of at least half an hour is given to the person. So the state government, subject to the control of the state government, we have this particular rule which says that uh, shall work continuously for more than 5 hours. A 30 minutes break should be provided. And where a worker in a factory works in a night shifts, it can be beyond midnight, and a weekly compensatory off shall be provided within 24 hours for such late night shift hours. And extra wages for the overtime for more than 9 hours. If a person is working, the extra work or the overtime charges should be paid, and it should be twice the rate of the ordinary rate. For example, if the rate is, say, 10 rupees, it should be twice. For overtime, it should be 20 rupees. So when it comes to the ordinary wage, when I'm taking the ordinary rate of wages, it means the basic wages plus the allowances. And if it is piece rate, per piece, the wage will be decided. And coming to the provisions relating to the wage and compensation. So wages during the leave period, for the leave allowed to a worker, he shall be be entitled to a wage rate equal to the daily average. And so what does that particular statement say? So it says that so the full-time earnings shall be exclusive of any overtime and bonus, but inclusive of DNS allowance and the cash equivalent of the advantage accruing through the concessional sale of the worker for of the food grains and any other articles. Okay. So what do we call a standard family? It means a family consisting of a worker, his spouse, and two children below the age of 14 years, requiring in all three adult consumption. So, I mean, the subsidized rates, whatever is being given, the food, the grains, or any other articles. So, this is how the standard family definition is given. And the adult consumption unit means the consumption unit of a male above the age of 14 years and the consumption unit of a female above the age of 14 years and that of a child below the age of 14 years shall be calculated at the rate of 0.8 and 0.6 for one adult consumption of the unit respectively. And payment of advance in certain cases. So Section 81 provides that where an adult worker has been allowed to leave for not less than 4 days and a child worker for not less than 5 days of the wages due for the leave period shall be paid in advance, that is before the leave begins. So before the person goes to the leave, the advance has to be, I mean, the payment in advance has to be done. And the mode of recovery of unpaid wages, any unpaid wages due to the worker can be recovered as delayed wages under the Payment of the Wages Act 1936. Now, coming to the provisions relating to hazardous process, the Constitution of Site Appraisal Committee, Section 41A, defines the following. So here, there's an application for the grant of permission for the initial location of a factory involving hazardous process. So the Chief Inspector of the State, who shall be the chairman, and either the representative of the Central Board of the Prevention and Control of Water Pollution appointed by the central government, or a representative of the Central Board of the Prevention and Control of Air Pollution, a representative of the state board appointed under Section 4, or it can be the state board appointed under Section 4 of the water, a representative appointed by the state board for the prevention and control of air pollution, a representative of the Department of Environment or Meteorological Department of India, and also an expert in the field of occupational health. So the site appraisal committee shall examine. So these all people will have in the site examination committee. They will examine the application for the establishment factory involving hazardous process and make its recommendations to the state government. And where any process relates to a factory owned or controlled by the central government or to a corporation or company owned or controlled by the central government, and the site approval committee shall have power to call for any information from the persons making an application for the establishment. And also the state government has granted approval in any application for the establishment or expansion of a factory involving a hazardous process. It should not be necessary for any applicants to obtain further approval from the central board. So once it has obtained it, it does not have to go for any other approval of the application. And the compulsory disclosure of information by the occupier. So the occupier has to provide with all the informations pertaining to the hazardous process and he will disclose the prescribed manner. Okay, so whatever has been asked will be disclosed in the prescribed manner and it will be given, the complete information will be provided by the occupier. And the specific responsible of the occupier in relation to hazardous process. So, I mean, he has to accurately maintain the health and medical records of all the workers, appointed persons, process, qualifications, and experience, and the provide for the medical examination of every worker before assigning any production involving such hazardous substance. And the powers of central government is to appoint an inquiry committee. So the inquiry committee will try to inquire the manufacturing of hazardous materials They inquire the standards of the health and safety observed, and they will also try to check whether the measures of the standards have been followed or not. And this inquiry committee will consist of a chairman and two other members from the central government, and the tenure will be decided by the central government. And we also have emergency standards under Section 41E, wherein the section states that in certain cases, when the central government thinks that the factory is unable to apply for certain security measures, then it is allowed to direct the director in charge of the factory to implement the measures. And coming to the permissible limits, exposure of chemical and toxic substances. So the maximum permissible threshold limits exposure of the chemical substances should be as per Schedule 2, and that has to be mandatorily followed. And provisions relating to the annual leave with wages. The annual leave with the wages are dealt under Section 79 of the Act. And if any worker working in any factory want to claim the annual leave with wages, the worker must have worked for a period of 240 days, that is in a calendar year, and that will enable him to claim annual wage with leave in the subsequent calendar. So how many days will be granted as a leave? For an adult, 1 day for every 20 days of working. And for a child, 1 day for every 15 days of work performed will be provided. And in case of female maternity leave for any under, it will not exceed 12 weeks. That is 3 months maternity. And right now, for the maternity period, full wages will be paid. And accumulation of the carry forward of leaves, in if any worker does not avail any earned leave, and this entitles him to carry forward the leaves for the next calendar year, subject to the maximum of 30 days in case of adults and 40 days in case of a child. And how to apply for leave with wage. If any worker wants to avail leave with wages earned by him during the year, he must apply in writing to the manager at least 15 days before the date he wishes to go on a leave. And the leave with wages cannot be availed for more than 3 times during any particular year. And the application to avail annual leave with wages for illness, if it is there, the purpose can be made at any time. And for leave with any application for leave which does not contravene the provisions of Section 79(6) shall not be refused by the authority to provide the leave. And coming to the scheme of leave to ensure continuity of work, the grant of leave can be regulated. For this purpose, the occupier or the manager should prepare a scheme in writing regulating the leave schedule. And apart from that, we also have the special provisions, power to apply the act to certain premises. The state government, by notification in the official gazette, declare that all or any of the provisions of the act shall be applied to any place wherein the manufacturing process is carried out, and the number of persons employed therein is less than 10 if working with the aid of power, and less than 20 if working without the aid of the power. And the persons working therein not employed by the owner. Okay, so once a place is declared, it shall be deemed to be a factory. And coming to the next one, rights and obligations of the employers and workers. Now, coming to the rights, a safe work environment. This is the right of the employer to see that these are there. Access to information related to potential hazards. Any request changes to avoid potential hazards. Participate in the workplace inspections. You need to inspect the workplace time and again. And do not have any discrimination, and refuse the work that puts the employee in danger. So these are the rights and the obligations: to provide employees a safe place with giving proper instructions to work in the timely manner, payment of the remuneration within the due time, granting of the holidays, weekly working days and rest time, and providing the training if required, and hiring the employees during the employment without overloading or overburdening the present employees, and to notify the employees working under fixed term employment about the contract of the vacant jobs, and the notify full-time employees of the possibilities of part-time work. Okay. And at the request of the employee, to provide employee with information about the wages calculated, any clarification required about the monthly payment or anything, it is the obligation. And obligation and rights of the workers. No worker in a factory shall willfully interfere with the misuse of any appliance, or willfully and without reasonable cause do anything likely to endanger himself or others, and shall willfully neglect to make the use of appliances and other things provided in the factory without proper care. And if any worker employed and finds contravention of any of this provisions, so he is punishable, and also he is prosecuted. I mean, he can be put behind the bars. And coming to the rights, every worker shall have the right to obtain from the occupier any information relating to his health and safety at the work, get the training from the employer for any work which is of a new phase, and represent the inspector directly in representing the matters of the anything relating to the factory, his health or work. And coming to the provisions relating to the offenses and penalties, the factory has certain rules, and for breaking such rules, you have the penalties, or it will be considered as an offense. So, what is an offense? I mean, if you are paying any salary less than the minimum rates of wages fixed by the employees working class, it you'll have a term of a penalty of 500 rupees, or it can be I mean, prosecution. You'll be put behind bars for a period of 6 months, or it can be both. And while imposing any fine for any offense, the court shall take into consideration the amount of any compensation already awarded against the accused. So in the earlier proceedings, if anything has been awarded, that will also be taken into consideration. And based on that, the compliances will be done. Now, what kind of compliances under the Act? So, the compliances are not exhaustive, but few are given here. The establishment is covered under the definition of scheduled employment. It is issued wage slips. It did not make any unauthorized deductions from the wages. And I mean, they did not deduct any fine from the wages. As the establishment has 8 working hours per day, and the minimum wages act has been prevalent, and the wages are being paid based on that. So these are the I mean, you have the compliances, few of the compliances which will be measured or verified. And coming to the offenses by companies, if the person committing any offense under this act, or a company, or every person who is at the time of the offense has committed was in charge and was responsible, the company, for the conduct of the business, he will be, I mean, he is legally punishable because of the act done. And what are the penalties? It can be the general penalties. The general penalties can be up to 1 lakh rupees. And it can also be a 2 years imprisonment, or it can be both. And in case of the provisions of the Section 92, whether any penalty for contravention of any of the provisions of the rules made under the Act have been done, it shall be the 25,000 will be the fine. And in case of an accident causing death, and if it is an injury, 5,000 rupees would be the fine amount. And certain cases where the punishment for the subsequent convictions can be imprisonment for a term period of extending 3 years, or it can be a fine of rupees 2 lakhs. So the code, the it can be both sometimes, wherein the punishment is severe, and the court may further, with the adequate and special reasons, can be impose a fine less than 10,000, and further where the contravention of any provision of Chapter 4 under the Section 87 resulting the accident causing the death or a serious body injury, the amount shall not be less than 35,000 in case of death and 10,000 in case of an accident. And the liabilities of the owner of premises in certain circumstances, this provides that when in any premises, separate building are being leased out by the owner to different occupiers for use of separate factories, the owner of the premises shall be responsible for the provision and maintenance of common facilities. And a penalty for obstructing inspector. And when an inspector has come for the inspection and you obstruct the inspector and not allow him to do his work, even for that, there's a penalty up to rupees 10,000 and imprisonment up to 6 months, or it can be both, and penalty for wrongfully disclosing of results. And it can be a 10,000 fine, or it can be a fine up to 6 months. And penalty for contravention of section, it provides punishment for 7 years of the imprisonment or a fine up to rupees 2 lakhs. Workers' offences, if any offence has been found, that is, if any worker working in the factory contravenes with the rules of the provisions, then a fine of rupees 500 will be levied. False certificate of fitness, if any worker submits false certificate of fitness to perform a task or a job, 2 months imprisonment will be levied, and as well as a 10,000 rupees fine. Double employment of a child, if any child works in a factory and works with another factory, then rupees 1,000 fine will be imposed on the parents, and also uh, it, uh, it, it can also apply to the person who gets the benefit from the child wages. It is not only the parent, it can be to the person who is actually involved in that. And onus of proving this is on the person who is alleged to have failed to comply with such duty. So if the person has been convicted or if the person has been fined, the onus of proving whether he is correct or not depends upon the person himself. So that is what the Factories Act states that. And coming to the next is the Trade Unions Act. The Trade Unions Act is passed in the year 1926. So what is a trade union? It is an organized group of workers who strive to help the workers in the issues relating to the fairness of pay, working conditions, working hours, or any other benefit or privilege which are they deprived. So a union, already the meaning of the union means a group. So people working in a particular factory or in a particular work, they form together, they come together and form as a union and bargain collectively. So for a trade union, it is important that there should be at least minimum 7 persons to start, and there is no restriction in the number of trade unions which can be established in the factory. There can be multiple unions. Though it is an advantage at one side, it is also a disadvantage. Multiplicity in the unions will reduce the bargaining power of the workers. And coming to the union. From the rapid growth of the First World War, and I mean the rapid growth of unions around the time of the First World War and the Russian Revolution, and also setting up of ILO in the year 1919, I mean, this industrial conflict has begun to increase. Over 1,000 strikes were recorded between 1920 and 1924. So why are these strikes and all? Because of the poor working conditions between in the factories where the workers were working. So for that purposes, to bring the uniformity, the prominent leaders and the trade unionists, they all have, I mean, revolutionized for the betterment of the workers. So during that year, the Trade Unions Act 1926 was passed by the British government, I mean, by the government, so that they bring on the harmony in the workers' life. So the Trade Unions Act 1926 dwells with the registrations of the trade unions, their rights, their liabilities, and their responsibilities. And coming to the meaning and nature and scope of the trade unions, labor unions or trade unions are organizations formed by workers, and it can be from related fields of the work, and they work for the common interest of its members. And the purpose of the trade unions is looking into the governance of wages, collective bargaining, working hours, disparity, whatnot. Every issue which is relating to the worker, that will be taken care by the trade unions. So, I mean, the trade union is an association of workers in one or more occupations, and it is an association which is carried out mainly for the purpose of protecting the interests of the members. So whoever may be the members, the trade union will try to strive to get justice to the members who are part of that particular trade union. And coming to the nature and scope, I think we hardly have time to discuss this. So the nature and the scope of the trade union and the further parts we will see in the next class. So any doubts you have? Okay, Vaishnavi, do you have any doubts?
No, ma'am.
No. Okay. So we will continue in the next session with the trade unions. Okay. Right, ma. Thank
Okay.
you.
Thank you, ma'am.